Holland Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome back to our latest and last Private Clients podcast in our Trust Matters series, where we are talking about a number of trust issues that we are seeing in Australia. Last week, we discussed some of the complexities around beneficiaries and rights to information. This week, we're going to move on to one of the most practical situations that we're often talking to advisors about, and that is a situation where the actual trust deed, which, as we've talked through all of our episodes before, is a fundamental aspect of the trust, where that trust deed has been lost. It's unfortunately a discussion that I have on a regular basis, and many of my colleagues have on a regular basis with advisors. There's no set formula in how to do and deal with this, but what we'll talk through today are some of the practicalities about how you can try and manage that situation, what you might be able to do as an alternative, and also looking at situations where you can't find the trust deed. What potential opportunities do you have to deal with that situation? Again, I'm joined by my colleague McLean Edinger from our Perth team, who heads up our estate disputes practice. And McLean, it's an interesting topic for us to talk about.
Yes, Will, it is, and good afternoon to everyone. Look, it's you talk about a lost trust deed, but people might actually think, sort of, what does that mean? Does that mean I can't actually find the document itself? What does that mean you don't have the wet signed copy of the trust deed? What do you actually mean by a lost trust deed?
There are lots of different things that fit under that heading. So we see at a practical level situations where people have completely lost the trust deed itself. And when I say completely lost, there's no original, there's no signed copy, there's no unsigned copy, there's no other documents that point to what those potential terms might be. I'll call that the worst case scenario. We also see situations where it's not the worst case scenario, thankfully, and you might have a situation where someone can't find the original, but they might have something in between. So they could have a signed copy or an unsigned copy that reflects what was ultimately signed. And then there might be a bit of a middle ground. We can't actually find the trust document, but we know when it was signed. We know that it was produced by this particular provider, and we've got a bit of a sense of what it would contain.
And is there anything that can be done to give yourself the best chance of not having a situation of a lost trust deed?
There are quite a few steps that you can take. I think first and foremost, it's really important just to set the scene and think about the practicalities, because if you don't have a trust deed itself, what does that mean? It means you don't know who the beneficiaries of the trust are. It means you don't know what the duties of the trustee and the powers of the trustee are. It sometimes creates a lack of certainty, and it can potentially lead to a situation where that trust fails because it just doesn't have enough certainty around the terms or the beneficiaries or the ability to administer the trust. And if the trust fails, that's a very significant issue.
Can cause significant tax issues.
And a lot of other issues as well. And that's why it's really important that when we're having these initial discussions with our clients, with our advisors that we work with, it's really important as the first step to make sure that we have exhausted every single avenue that we can in terms of trying to locate that trust deed. We've worked on a number of these matters with clients. We also have had a number of these matters go to court, and our colleague David Dickens, who was on our earlier podcast, ran one of the more successful and recent cases about lost trust deeds, the Cleve Group matter. And that was a really insightful case to look at because there was a very prescriptive process that we went through in terms of trying to identify and locate the original trust deed. And that was doing things like talking to members of the family who are involved in the establishment of the trust, talking to the accountants, the settlor of the trust, the lawyers who are engaged, anyone else who might have had dealings with that trust, so might have received a copy of that trust, such as banks, financiers, other lawyers who might have worked on transactions, accountants, financial advisors, the ATO, and there was a very comprehensive process that was gone through. And one of the reasons that process was so comprehensive, A, was to find the trust deed itself, but B, to actually inform the court when it came to the time to make a court application that we had done everything that we could do and that's really important, left no stone unturned, so that the judge has a very good sense, well, we've done everything that could have been done. Therefore, it's really then up to the judge to look at what evidence could be located to then make a decision about the terms of the trust.
And I think it's important that not to be quick to run off to court and say we can't find the trust deed, because you're going to have to obviously put evidence before the court of what steps, and literally this will be the first question the judge asks, is what steps have you taken to try and find the lost trust deed? And if you're not able to actually satisfy the judge that all the reasonable, or as you put it, exhaustive steps have been taken, he's basically going to say there's potential costs, adverse cost implications, but the judge is probably going to say, well, I'm going to make orders that you do X, Y, and Z to actually try
which
and
then
find
slows
this
down the
trust deed,
process
and costs a lot of money.
That's right. That's right. So when you get to that stage, if you do have to go to court, really putting yourself in the best position to make sure that process goes as smoothly as it can, to be properly informed so that you can help a judge make a decision, it's a really important aspect to consider.
So if you've gone through that process and you've spoken to the firm who drafted the will, the family members, prior trustees, you might have gone to the safety deposit box at the bank, all sorts of things. But it is pretty clear that there is a lost trust deed, and you want to try and get an order of the court to rectify it. What can actually be done?
Well, this is where the information becomes really important. So the more information that you can get and you can put before the court, the more of a chance you have of getting an outcome where the court might make an order or make a declaration about what the terms of the trust can be. So if you look at a situation where you might have a copy of the trust deed that might not be signed, so a scanned copy, that's a really good situation to have. There might be things like letters of advice about the structure, about the key terms of the trust. So often the key terms are set out in a schedule. You might actually have a copy of the schedule, but not the rest of the trust deed. You might know which provider produced that trust deed, especially if it's one of the more common types of trust deeds, and you might be able to go to that provider and get a copy of their standard deed at that point in time. And if you couple that with the schedule, it's giving you a pretty good sense of what the terms were. It's really thinking about the more information I can give to a judge, the easier it makes it for the judge to say, these are effectively the terms of the trust, and I'll make an order or a declaration to that effect.
And in your experience, what's sort of the nature of the judge's role? Are they effectively trying to say, well, this particular copy of the trust deed is going to be confirmed as the terms of the trust, or do they potentially sometimes have to essentially add extra terms or powers within that trust deed?
It's really looking at the evidence that's there and relying on that evidence or those documents, that piece of information, to reconstruct what the terms of the trust are. There's a hesitancy to add rules, regulations, powers in which we're not certain we're in the trust deed itself. So again, the more information, the more evidence you have, the more of a chance you have of getting an outcome which then allows you to continue the administration of the trust. Now, that's ideally where we want to get to. And if we look at some of the cases where the judges have considered that, you can look at situations where you've had an unsigned trust deed that's been accepted by the courts. You've had secondary evidence such as letters from accountants, a schedule to a trust deed, minutes, tax returns, putting all of that together. That's been enough for a court to hold that the trust still exists and still continues and provides some rules around how the trust can operate. Getting the schedule is a really helpful situation, or having a letter that describes the terms of the schedule, especially if you can point to another trust that was established at a similar time by the same provider. Couple those two together, that's giving you a pretty good outcome as well. But you do get situations where you can't find the evidence, and in those situations where you can't find the evidence, that's where a judge is not likely to make any orders or declarations about the terms of the trust, because they just don't have the material in front of them to be able to do that, and that's a problem.
Particularly if there's been assets in this so-called trust for a long period of time, and potentially the court's going to have to make a finding that they can't say if a trust is no longer on foot. Or one thing from a proactive planning point of view, and a lot of advisors will get their clients to sign more than one original copy of the trust deed, which I think most firms will do sort of 2 or 3. And it's obviously really important to protect one copy of the original trust deed, and some of our clients will ask us to hold one. One will then be provided to their accountant, and then one will be held by them at home, which in my experience, that's the copy that often goes missing. But I would presume the most common scenario we see is where there may be a copy of the signed trust deed, but they can't find an original signed copy. Does that require an application to the court?
Not necessarily, and this is probably one of the more practical considerations. There are ways that you can provide enough comfort to third parties that you're dealing with, and often this is how it comes about, because you need to deal with the bank or you need to deal with someone in a transaction, and they will want the signed trust deed. But if you can't find the signed trust deed, but you've got an unsigned copy, or you've got something that's close to the unsigned copy, you can often prepare a document called a deed of confirmation, for example, which basically says the document that's annexed or attached to this deed reflects the terms of the original trust deed, subject to these adjustments. And those adjustments might be, for example, some adjustments to the schedule of the annexed sample trust deed. And in many cases, that's sufficient. That's something that can be done quite easily. It can be done quite quickly, and it can be done quite cost effectively, as compared to a situation where you really need that court declaration or that court order because you've got something significant, be it a tax issue or a transaction where you really need certainty about the terms of the trust. That's where you're off to court. And obviously when you go off to court, that's a time-consuming exercise, it's a costly exercise, and there is that element of uncertainty. But in many of these cases, that has to be done because there is something that's significant hanging on the existence of that trust, and we need that certainty from the court to say that this is the terms of the trust.
I would say that there's probably a temptation by a lot of clients to push for the deed of confirmation because it's straightforward, it's quick, it's cheap. And if you have a signed copy of the trust deed, and you can clearly show that that is the trust deed, obviously, that everyone's been administering the trust through for a long period of time, that the deed of confirmation is appropriate in that situation. But you need to be careful, and you should absolutely get advice around using deeds of confirmation when it's not that clear cut, because to try and effectively confirm a trust that it's the deed of confirmation itself might not be considered valid by the court, it sort of means you're prolonging the problem. If at some point a third party like a bank wants to see a certified copy, they're not comfortable with the deed of confirmation, you may have an issue that effectively, from a tax perspective and a distribution perspective, you've been dealing with the trust for a further 10 years that actually it may be found there isn't a trust on foot.
That's right. And that probably goes into the final point that we'll just talk about briefly today, and that's the situation where we can't actually get that evidence, or we don't have enough evidence to convince a judge about the terms of the trust, and what happens in that situation. And what the courts have said, and there's been a number of recent cases, Vanta and Mantovani in Victoria, for example, where the courts have essentially said, look, if that trust fails for uncertainty because we can't get the terms sufficiently confirmed, and I should say with Vanta that was the decision at first instance, which was reversed on appeal, but there's comments from the judges in that in terms of how we would deal if that trust had actually failed. And what that really looks at is who is the person who settled or put that property into the trust. And that's really your starting point. So you've got the normal settlor, $10 to settle the trust itself. It's not really looking at that person. It's more so looking at if Maclean, for example, has settled a property into that trust and there's been no consideration for that, then that property is most likely going to go back out to Maclean on a resulting trust if the trust itself fails for a lack of certainty. So that's often the flow-on implication if a trust fails because we can't find the terms of the trust. And in many cases, that can cause a number of different problems. So again, it goes back to that point about when you are setting up a trust, do it properly, make sure that you've got copies of that trust deed, make sure that the originals are securely stored, and ideally you would sign off on 3 original documents so that there is always a number of originals that are available to avoid these situations coming up. So with that in mind, we might close out this series. So that was episode 4. Thank you everyone for listening. Please reach out to us if you do have any questions. We're always happy to chat, to help share some of the experiences that we've been seeing and hopefully help you avoid a number of those issues that we've talked about as well. I might just do a quick note. We will have another podcast series coming up next month, and that one will be talking about business succession planning. That's often a key element that's missed in people's succession planning when they're just looking at their personal aspects. So in that next podcast series, what we'll really be focusing on is how to successfully transfer control of a business, and some of the common issues that we do see when people lose capacity, for example, or also on the death of key people who are involved in that business. Again, proper preparation can avoid a lot of those issues. Look forward to discussing that with you more. Stay safe and speak again soon.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.